Namaste, this is Atuldat from LawQuest. Today I will be explaining the topic of Preamble of the Indian Constitution. The synopsis of what I am going to explain is as follows. Introduction, meaning, brief introduction. Can the Preamble be amended or not? The main points of Preamble, case laws and conclusion. Introduction. Preamble is derived from the Latin word preambulus, meaning to go before or an introduction. The idea and provision of preamble was borrowed from the Constitution of USA, and the language used was from the Constitution of Australia. It is the introduction and basic structure of the Constitution. An eminent jurist and constitutional expert, N.A. Palkiwala, called the preamble as the identity card of the Constitution. Meaning, preamble is an introductory statement to any act or legislation, and in our case, it is an introduction to the Constitution of India. It is an indicative of the philosophy, purpose, objectives, ideas, and aspirations for the presiding law, and it is a blueprint of the Constitution. The preamble in a Constitution presents the intention of its framers, the history behind its creation, and the core values and principles of a nation. The preamble basically points out the following things, such as source of the Indian Constitution, its objectives, and date of the adoption of the preamble. Every statute or laws has a preamble because it tells the scope of a statute. The spirit of the Indian Constitution is depicted in preamble. Preamble is also called as the soul of the Indian Constitution. The source of the Indian Constitution is the people. Brief history of the preamble. While our Constitution was being drafted, J. Nehru presented an objective resolution from the Constitution in front of the Constituent Assembly, mentioning the rights, liberties, and ideas and expressions behind the Constitution. This draft, which was the objective resolution, was presented on 13 December 1946. The objective resolution was adopted as preamble on 26 January 1950. Since the adoption of the Constitution, preamble has only been amended once through the 42nd Amendment, from which 3 new words were added in the preamble, namely socialist, secular, integrity. Can the preamble be amended? Article 368 states, power of the Parliament to amend the Constitution. But the Supreme Court, in case of Keshav Nanda Bharati case, said that the preamble is a part of the Constitution. The Parliament has the power to amend it, but the basic structure cannot be amended. The main points of preamble are as follows. We the people of India, sovereign, socialist, secular, democratic, republic, justice, liberty, equality, and fraternity. These 10 points will be explained as well. The term we the people, this title we the people refers to that people have given the power to make the Constitution, and this title has been borrowed from the American Constitution. The power to make the Constitution is given by the people basically, and not any other authority. Second point is sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state. There is no authority above it, and it is free to conduct its own affairs both internally and externally. The third, which is socialist. Before the term was added by the 42nd Amendment Act in 1976, the Constitution had socialist in form of certain directive principles of state policy. The term socialist used here refers to democratic socialism, that is, achievement of socialistic goals through democracy, evolutionary and non-violent means. The fourth point is secular. The term secular too was added by the 42nd Amendment Act 1976. It basically means that India has no official religion and the government respects all religion. Article 25 to 28 gives fundamental right relating to religion. Fifth point is democratic. It basically refers to the doctrine of popular sovereignty, that is, possession of supreme power by the people. In India, there is two types of democracy. One is direct and the second one is indirect. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. The sixth point is republic. The term republic used in the preamble of our constitution signifies that India has elected representatives as the head of the state. The President of India is elected head of the state. The President of India is not a hereditary monarchy. He is an elected person chosen for limited period of time, that is 5 years. The seventh point is justice. The preamble intends that justice must be given to every citizen irrespective of poverty, richness, caste, race, religion, sex, political power. Justice basically aims at attainment of common good. Justice includes social, economic and political justice as well. The eighth point is liberty. Liberty implies the creation of conditions necessary for the fullest development of personality of an individual, which is essential for social progress. Liberty is one pillar of democratic system. Liberty implies liberty of thought, expression, belief, faith and worship. The ninth point is equality. Equality means equality of status and of opportunities. As all human beings are born equal, they should be provided with equal opportunities in all walks of life under equal circumstances. Equality ensures equal protection of law. The 10th point is fraternity. Fraternity means the spirit of brotherhood among all the sections of the people of India. Fraternity is necessary to ensure both the dignity of the individual and unity and integrity of the nation. Case laws for preamble. The first case law is Beru Bari case. In this case, the Supreme Court held that the preamble was not a part of the constitution and so it could never be regarded as a substantive source of power. It has limited application and can be resorted to where there is any ambiguity in statute. If the terms used in the constitution are ambiguous or capable of two meanings, in interpreting them, some assistance may be taken from the objectives enshrined in the constitution. The second case is Keshav Nanda Bharati case. The Supreme Court rejected the above view and held that preamble is part of the constitution. All importance has to be attached to the preamble in a constitution and it should be read and interpreted in light of grand and noble vision expressed in the preamble. The third case is Indira Gandhi versus Raj Narayan. Indira Gandhi, the then Prime Minister, and Raj Narayan were rivals in general election of Parliament. Raj Narayan filed a case against her contesting that she misappropriated her power in the election. The Allahabad High Court quashed the election of Indira Gandhi as void. To protect the seat of Prime Ministership, the Parliament inserted Article 329A protecting Prime Minister and Speaker from any election disputes and guaranteed for their term. The Supreme Court said that certain provisions of Article 329A is against the basic structure theory and is against the essential element of democracy mentioned in Preamble. The Supreme Court therefore struck down certain provisions of Article 329A as unconstitutional. Preamble is key to interpretation of the Constitution. It is a brief introductory statement to the Indian Constitution. The fourth case is S.R. Bommai versus Union of India. It was held in this case that secularism is the basic part of the Indian Constitution. With this, I would like to end the topic of Preamble. Thank you. Jai Hind.